Hello, everyone. Welcome to the Extended Producer Responsibility for Plastics and Packaging Compliance Issues and a Treaty Negotiation Update, co-sponsored by the Environmental Law Institute and the International Network for Environmental Compliance and Enforcement, or INES. My name is Susanna Dibble, and I'm a staff attorney here at ELI and the Managing Director for INES. INES works to raise awareness for compliance and enforcement, develop networks for enforcement cooperation, and strengthen capacity to implement and enforce environmental requirements. You can find out more about our work on our website, ines.org. For the webinar today, I will be joined by Lee Paddock as co-moderator. Lee is a senior advisor at INES and a visiting scholar at ELI. We also have an amazing group of speakers today. Thank you to Mallory, Chocho, Rio, and Alexandra for joining us to break down and discuss such a timely topic. Now, following their presentations today, we will be taking audience questions. Please don't wait to submit any questions you have. You can use Zoom's Q&A function at any time throughout the webinar, and our moderator and speakers will be able to see it. We encourage you to use the chat for any observations and comments, but we will be pulling discussion questions from the Q&A box at the bottom of Zoom's interface, not the chat. Today's webinar will be recorded and posted on the event webpage to view later, so if you can't stay for the whole webinar, the recording will be available within a few business days at eli.org. And before I pass it to Lee, I'll give a little bit of background on the very important issue we're covering today. As many of you are likely aware, the rate of plastic production continues to grow and is expected to reach up to 1.1 billion tons by 2050. Yet less than 9% of all plastic produced globally is actually recycled, and only 10% of that amount is recycled more than once. One of the key tools identified to reduce plastic waste, both on land and in the marine environment, is Extended Producer Responsibility, or EPR. EPR is a key tool for facilitating the circular economy and achieving more sustainable production and consumption. EPR puts the responsibility for end-of-life project management on plastic producers, thereby incentivizing manufacturers to design products in a way that minimizes materials use and facilitates repurposing or more effective recycling. Though EPR programs for electronic waste have existed for over 30 years, EPR for plastics is a more recent development. 7 states here in the US have passed EPR laws on plastics, and more than 60 nations have adopted EPR laws around the globe. Recognizing the scale of the plastics problem, the Intergovernmental Negotiating Committee developed an internationally legally binding instrument on plastic pollution that addresses the full life cycle of plastic, has been negotiating a treaty since 2022. The second part of the 5th session will be held in August in Geneva. The end-of-life issue, including the potential role of EPR systems, is a key issue for the negotiators, and we'll discuss in greater detail today. While not a solution by itself, EPR is a necessary tool for addressing plastic pollution, protecting human health and the environment, and achieving a more circular economy. So thank you for joining us, and now I'll turn it over to Lee.
Thank you, Susanna. A couple of quick introductory thoughts. So my first exposure to EPR was in the late 1990s, so over 25 years ago, and it was being considered in the US by then President Clinton's Council on Sustainable Development. But there was a lot of pushback at the time in the US from industry, and the idea, at least at the national level, did not take hold. But shortly thereafter, EPR became a kind of a regular tool in the European Union. It's the plastics issue, of course, as you all know, is incredibly important. And as Susanna mentioned, there's an awful lot of plastic being produced, and it's growing at a rapid rate, with only 9% of plastics being recycled worldwide. This is a problem for a lot of reasons, including the ocean pollution by plastics, but also increase law enforcement problem related to illegal and improper shipments of plastic waste around the world. Next slide, please. So as I mentioned, the European Union took up EPR fairly early. They had a packaging EPR statute as early as 1994. And then end-of-life vehicles, waste electronics, batteries, and textiles have all been subject to extended producer responsibility in the European Union. Next slide. And EPR is rapidly becoming an important tool worldwide. And these are just a few examples. Canada, Chile, China, India all have EPR legislation. Part of this results from the fact that there's so much plastics being put into the environment. But another important part of the EPR world is that the cost of managing plastics is very high for local governments who have to manage waste. And increasingly, there's concern about the health impacts because a lot of plastic wastes end up being incinerated, and there are health effects associated with that method of disposal. Next slide. In the US, EPR was fairly common in approach for waste electronics, beginning in around 2000. And 26 states in the District of Columbia have EPR legislation. The state of Minnesota was an early adopter for EPR legislation. We're lucky to have a speaker here from the state of Minnesota, where I worked for more than 20 years in the state attorney general's office. And so they have a lot of experience that they can bring to the table about how to manage effective EPR programs. Next slide. And packaging EPR is beginning to be adopted in the United States. As Susanna mentioned, 6 states have now adopted EPR packaging legislation. My own current home state of Maryland just adopted that legislation about 2 months ago, and will be implementing it over the next several years. Oregon, California, Colorado, and Minnesota also have EPR legislation. Next slide. One of the other, I guess my final thought on this too, is that traditional EPR legislation focuses on the waste end of the EPR life cycle. And that's important because of managing the waste, keeping it out of the environment, lowering costs for local government. But as the treaty negotiations indicate, there are 2 other really critically important issues associated with EPR. One of the limitations on EPR reuse of plastics is the chemicals that are in plastics, which can inhibit reusability. And that will be part, or has been part, of the treaty negotiations. The other important issue is designing plastics for recyclability. In the US, and I think in many places, only 2 types of plastics out of the 7 that have been identified and are often seen in the recycling symbol on plastics are actually routinely recyclable. Thus the very low 9% recyclability rate. So both chemical use in plastics and designing plastics for recyclability are critical issues that the treaty touches upon, but they also need to be considered, I think, by countries around the world as they work on their extended producer responsibility programs. With that, we'll turn the program over to our speakers, and thank you.
Thanks, Lee. And I'll turn it over to Alexandra Harrington now.
Perfect. Thank you all so much. Thank you, Lee, for the introduction, and Susanna and Sarah, thank you for all of the work in coordinating this. It's lovely to see so many people joining us, and hopefully we will get some interesting discussions coming out of this. So I have the job of framing, I think, the Global Plastics Treaty negotiations. Many of you will be familiar with them, but I want to kind of take us on a little journey, which is a sentimental journey for me in many ways, through the INC process, the Intergovernmental Negotiating Committee process. So there's a background of kind of when we're talking about the treaty, what we're talking about and how it has moved forward, and then also talk about specifically EPR and how EPR as a concept has been introduced in the treaty context and hit certain high points of proposals for inclusion, including proposals for an actual dedicated article, and has now been scaled back a bit, just to give you a sense of where the negotiations have gone so far. I do think it's important before we get into this anymore, just to highlight also from the slides that we saw from Lee, that there is really a fundamental debate, a fundamental discussion going on now in the context of the treaty, as it has been certainly for the past several INC meetings, about whether this treaty will be a full life cycle treaty, whether it will really only address the downstream, the waste management elements, or whether it will, as it was requested to do by the UN Environment Assembly, actually look at the full life cycle and include the full life cycle. In either scenario, EPR will be very important. But obviously will play a role in different ways. So it's just something I think to provide a framing for. So how did we get to the plastics treaty? If you can actually read the text on the slide in the little box, I'm impressed. We started off this whole journey towards a treaty with the UN Environment Assembly first convening and authorizing an open-ended working group. And the open-ended working group was really intended in the post-COVID context to explore whether we needed a dedicated treaty to address plastic pollution, whether we needed a global framework or something that was not binding law. And ultimately, it came up with a set of recommendations that included having a dedicated international treaty, so open to any country to join the process that would look at plastic pollution as a dedicated area, a specific area for a legally binding treaty, not something like the Global Framework on Chemicals, which is a framework and is not binding, although highly valuable and persuasive. With this in mind, the UN Environment Assembly, affectionately known as UNEA, adopted Resolution 514 in early 2022. And this created the mandate for the Intergovernmental Negotiating Committee, also known as the INC, which became the process for having the negotiations towards the Plastics Treaty. The specific resolution authorized the convening of an INC, which refers specifically to the country. So when we talk about the INC having done um, anything, mandating a zero draft, mandating a compilation document, we are referring to the countries. There's a very important role for stakeholders. There's a very important role for observers and rights holders. Many of us have been there in these capacities, but the decisions themselves are actually taken by the states. And so those states were authorized to come together. The UNEA resolution set out a negotiation timeline. So to start at the end of 2022, and then the ambition was to finish by last year, as many of you know, by the end of the year in Busan, in the Republic of Korea. Obviously, that didn't happen, but that was the authorized timeline. And the authorized parameters were 5 negotiation rounds. This is why, as both as both Susanna and Lee commented earlier in reference to INC 5.2, why we have a 5.2. Because technically there were 5 rounds that were authorized. We already had them when we were in Busan. But rather than calling the meeting closed and gaveling the meeting closed, which would say effectively we couldn't do this in 5 rounds, and require additional authorization or guidance from UNEA, the decision was taken for the chair to instead adjourn the meeting to its next convening. And so this will be considered 5.2 because it is still under the umbrella of the fifth session, then this is all right. Theoretically, we could have multiple iterations. We're all hoping this is not the case, but that still comports with at least the number of negotiation rounds authorized, if not actually the timeline. The UNEA resolution also created the basic parameters for what the plastics treaty should contain and address. And I always pause here to explain that in no way was the treaty intended to be a ban on plastics. I think in the beginning there was a great deal of media attention for this that looked at it as only banning plastics. It is not. The actual scope is to create an international legally binding instrument on plastic pollution, including in the marine environment, but it is not to ban plastic per se. It is definitely to allow us to rethink how it is used. And just finally, for kind of reiteration, the UNEA resolution itself made many provisions for stakeholder engagement and observer engagement and participation throughout the process. You may have heard some criticisms of this coming out of some of the INCs, but I did want to point out that is in the resolution. Um, on our world tour of negotiations, the first one was INC 1, which was held in the end of 2022 in Punta del Este in Uruguay. Um, this one was very much open. This is where we saw a lot of the initial discussions, ideas from states and observers as to what should be in the treaty, and then what the outcome would be in terms of having a path to the next negotiating session. This is where we first saw the idea of extended producer responsibility really coming into the discussion and the dialogues. Although at that point we didn't necessarily have text to look at. We really were just hearing more ideas and views from the various countries. When we got to INC2, which was held at the end of May into June in Paris, there was a hope that we would have a lot more finalized text, or at least an agreement on some things that could go into a zero draft, including many of us had hoped extended producer responsibility. But there were a number of procedural issues that came up, which severely inhibited the actual negotiations process and which had an impact of giving us basically only a day and a half of full negotiation time before we were able to, or we were required to then leave and gavel the session closed. So we didn't have a great deal of movement. There was what we call a zero draft, and the zero draft is essentially a first draft of the treaty, which really was quite skeletal and gave us a number of different elements that could be included that the Secretariat had compiled from the various negotiation sessions during INC2. That was released in advance of INC3, which was held in Nairobi in November of 2023. And there was a much more robust decision on, or discussion on what the negotiation text might look like. There were many prolonged discussions, including things on intercessional work. So we didn't have any real agreement on text, but we did have a lot more discussion about text, including extended producer responsibility, which we'll get to momentarily. When we got to Ottawa in INC4 in April of 2024, there was a hope that we would have a great deal more forward progress using what we termed the revised zero draft. So the second iteration of the zero draft. But there was little movement on text, um, which made it very difficult to try to progress into Busan. There was agreement on intercessional work, so to hold two different working groups and allow national experts to be appointed to these working groups to look at both financing and capacity building and potential financing mechanisms for the ILBI, as well as elements of how we define and what the parameters should be for chemicals of concern, plastic products, and plastic product design. These meetings were held online over the course of a month, so 3 each. I was lucky enough to be a national expert, so I was part of these. We had 3 online sessions for each working group. And then we also had an in-person meeting in Bangkok, which is where we have some of these lovely photos I took, these very calming photos. EPR did come up in both discussions in a more limited sense, not necessarily as much as some of us might have liked, but it did come up across the board in both of the contact groups and both of the discussion groups. However, there was no real outcome. There was no agreement moving forward. The hope had been that there would be intercessional work and that that work would then provide at least an agreement on some scientific and technical elements to forward to INC5. But unfortunately, that was not the case. And when we came to Busan for INC5 in November of 2024, obviously the aim of the negotiation round itself was to have a final treaty. This did not happen. We had actually a really interesting series of documents that came out. And I'm going to mention this here, and we're going to then have a discussion about some of the text, but it is very confusing. The slides I wanted to reiterate will be available and hopefully have a bit more of an explanation of some of these particular documents. But at the end of Ottawa, at the end of INC4, the INC, so all the countries together, um, had requested that the Secretariat make a compilation document which would reflect the revised zero draft text that was used as the basis for negotiation at INC4, along with all of the different proposals for various articles and elements that had been made during the Ottawa round of negotiation. That document was released and it was over 70 pages and it had thousands of brackets to indicate that there was disagreement on text or whether to include text or to remove text. This was all disagreed on. Um, in the hope of moving things forward and in the hope of being able to meet the INC5 deadline at 2024, the chair of the INC himself took the step of creating what was called the first non-paper, the chair's non-paper, which is indeed a paper. The name is somewhat confusing. It is indeed a paper, and it is indeed a proposal for essential elements that could be in the treaty, really stripping out a lot of things that had caused controversy and trying to get down to areas that could be the source of agreement. It is called a non-paper because it was not requested or authorized by the INC. It's something that the chair decided to do on his own. So it technically had no legal standing. It had not been approved. It was approved as the basis for the negotiations at INC5 on the understanding that it could be amended in many ways. It could have textual proposals made, and indeed we saw this happen throughout the week of negotiations. We saw the issuing of two different additional non-papers. This is where it gets confusing. So we have one from the 29th of November, we have one from the 1st of December. They contain often different terms, but they were efforts by the chair to try to propose additional fast forward for what the treaty might look like. Ultimately, none of them were agreed, so we are now going to Geneva in August. However, I think it's really important for us to understand the chronology when we're talking about certainly EPR and a number of other issues as well, to see where things started and where we are now, and to discuss amongst ourselves, or at least start a discussion of whether at this point we should think about arguing for them to be included again, or how if we do adopt some of the later non-paper elements, how EPR might fit in when we get to the conferences of the parties. So we know that EPR was in the ILBI discussions from the beginning. Going over some of my notes from INC1, it was certainly quite present. And we also had in between the sessions, in between INC1 and 2 and 2 and 3, intercessional questionnaires that sought inputs from countries as well as from observers, and all of them had references to EPR at some level. So we know it has been a present theme. It's also been a theme that has had some pushback, especially from producing states, as we might imagine and expect. It certainly has had its share of detractors as well. Now, I won't go through all of the textual elements, but I did want you to see that in the zero draft, so in the first iteration of what a treaty might look like, there was a dedicated article for EPR. It had two options that were presented. Option one was much more robust in terms of it being a shell language requirement for states to include extended producer responsibility, and also to have this be part of their reporting requirements. Option two was much more soft in language, so is each party is encouraged to establish, so much more voluntary, but still there, and actually gave us a bit more of an understanding and articulation of what EPR might be and where it might be included in various economic aspects and supply chains and life cycles. It also was included not only in this dedicated article, but also throughout in the idea of national action plans under the zero draft for reporting. In the revised zero draft, again, we saw that there were several proposals for extended producer responsibility. One was the rather dreaded option zero, which means no, no option, no inclusion, not to have it. The others, again, I won't go through all of this, but did reflect a dichotomy between those wishing to have a mandatory provision, which in this case was extended a bit, and greater definition was provided in terms of what it might be, with then reporting requirements and oversight by the governing body, meaning the conference of the parties. Other options being much more voluntary in nature, but still having the connection to the Conference of the Parties to create oversight and enforce oversight measures using the national plans. We also had an option three. We had many options. We had an option three, which sought to include multinational corporations and their home states in a way that the others did not. And also, again, a much more voluntary element in option four. We saw a number of different expanded areas where EPR was connected directly through the textual language as well, including repair and refill for plastic products, many aspects of recycling, waste management, even the financial mechanism, as well as things like technology transfer and national plans, and also various annexes. In the compilation document, which was again not used for the basis of negotiations, but still very much, I think, important, and many countries came back to the positions that they had articulated from INC4, which were reflected in the compilation document during INC5. We did see the dedicated article still proposed, although it was bracketed, which in international parlance means that there was a disagreement. They reflected a disagreement on whether it should be included or not in terms of extended producer responsibility. And we really saw an argument in the compilation document text as to whether we call it extended producer responsibility or only producer responsibility. We saw a much longer potential article. The same dichotomies existed. So we still saw a lot of questions coming down to whether it would be international requirements or national requirements, whether they would be binding or voluntary, and then the specific measures that might be included. Um, Additionally, we saw that the same areas, same extra areas outside of the actual article proposal were included in the compilation document. However, when we get to all of the chair's non-papers, the EPR article has been removed. So it has been removed in its entirety. There is in the first non-paper a single reference to EPR in the concept of plastic waste management and as a voluntary component. In the 29th of November non-paper, we still had the same language on plastic waste management and EPR, and EPR was also included under some aspects of the financial mechanisms article. And the same thing was then proposed for the 1st of December non-paper. So what we've seen really in the context of the plastics treaty is very much an advance, a very rapid advance of EPR as something that many states argued was critical. Many states argued needed to have its own dedicated article, and provisions and understanding of what EPR means, although there was disagreement as to exactly how binding or voluntary it should be. In the subsequent rounds of negotiation in the non-papers, we've seen an effort to scale this back. I think very much largely because we're trying to get to an agreement on some type of treaty mechanism. And there is a concern that EPR is something that might be better placed in the conference of the parties discussions rather than in the treaty text itself in order to get a very quick agreement. But it is something that is still very much important and very up in the air at this point. So I think I'm happy to take any questions. I will stop. I believe that was my last, yes, it was my last slide. So I will stop my presentation at this point and be happy to take any questions. And also would just, I think, challenge all of us who are on this event and all who are watching it to look at these different aspects of EPR in the treaty and figure out what areas might be connected to EPR that still could be very powerful, even if it isn't included as its own dedicated article in the treaty text, because we don't know if that will be brought back in. So Sarah, shall I give I don't know how to give the control back, but however I do that. Or Susanna?
Yeah, she'll be able to take it back on it.
Okay, perfect. It's excellent.
Thanks, Alexandra. I'll pause briefly for any
Yeah.
questions that are treaty specific, since this is our only presentation on that. And we had one that was submitted asking if there were any updates related to the treaty or EPR specifically at the recent G20 negotiations.
So it has been part of some of the negotiation elements. It has not been subject to a specific statement at this particular point. Plastics treaty has not been either. There is a very interesting dichotomy now coming up between the G20 members, especially with uncertainty with the US. So we are still uncertain as to how much the US will be planning to participate in the negotiations, if they will be present at all, and then if they are present, what their stance would be. Obviously, we know their former stance from the efforts leading up to Busan, but that will presumably have changed with the new administration. So getting an agreement on that has been quite difficult. I would say for those who are looking to see kind of what information we might find out early or what we might know before we go into the next negotiation round, that there have been regional meetings going on. And at the end of June, so literally the end of June, June 30th, into the beginning of July, there is the heads of delegation meeting, which will take place in Nairobi. And this will be again another effort, like we saw the chair having before INC 5, to create some type of momentum and find areas of convergence to move the treaty forward. So the outcomes of that will be very interesting to see. It will be, I think, quite telling to see if perhaps we do have another iteration of a chair's non-paper or something like that at any particular point coming out of the heads of delegation meeting. But at this point, the G20 has been very silent. G7 obviously has been very silent because this is still quite controversial in those settings.
Great. And I'll
And
ask one other question I'll sort of combine two here. One about what makes EPR such a toxic subject in negotiations, and then how EPR might work on more of a global level, since we've seen it mainly at a state or country level.
Exactly. And I think toxic might be a bit much. I think it's very divisive in the sense that obviously there are countries that are concerned that they not impact their industries, and they do have lobbies and they have other forms of political representation that do come into play. At the same time, as countries that are receiving a great deal of plastic pollution and having to handle it and having to spend their own resources, which they often don't have, to figure out waste management systems, et cetera, to actually handle this type of waste, have become increasingly adamant that this does need to be included. We did see early on a proposal for a plastics fee, I didn't put this in the slides because I really wasn't sure that it would fit in well or that we would have time. But the question about a plastic fee lingered on until I think INC 4 into 5, and then it really went away. And that was also highly controversial. So any way of trying to extend responsibility for producers financially or have some type of fee-based mechanism to provide funding for remediation has proved quite difficult because we are on an international scale and because countries have different priorities. And I think it's really fundamental also to figure out uh, what this treaty wants to address because EPR will have different meanings. And I think this is also where we see an argument. EPR will have different meanings if it is a full life cycle treaty, as was requested by UNEA, or if it comes to be really a downstream and waste management treaty, as some countries have requested. So that's why I think at this point it's still very divisive. The idea of having it on a global level is to try to bring some type of parity. So we see it a lot in the reporting requirements, because we the idea is we want countries that are in a position to have to put EPR into place to provide transparency, to provide information, and have some leveling of the playing field, so that we don't just have some countries or some political subunits like American states. Um, that are doing this and others aren't, and we have kind of unequal treatment of it. It is a problem when we're thinking about it internationally because each state has its own experiences and has its own standards. And there are some states where it will not be relevant from an imposition of EPR perspective, but it will be in terms of making sure that they get information coming from the EPR system. That's a very long answer, but um, but there's that. Is there anything else?
We
Lee, have I?
Yeah, I had a couple, this is Lee, I had a couple of quick questions.
Yeah.
One, given the fact that EPR is not heavily addressed in the non-paper, what might you expect would be the best reasonable outcome from the negotiations that would at least keep EPR on the table
Yeah.
and keep EPR in front of any future conference of the parties?
So it's an excellent question, and in an ideal world, we would see the EPR article brought back in. Obviously, in reality, if it is not, I think at the very least, what we have, which is on the screen, from the first non-paper. So the idea of the voluntary component, at the very least, for plastic waste management, as well as tying that to financial mechanisms, would be very useful. Um, there are many points, this is not the only one, there are many points and many intersections where, um, because of the contentious nature of the treaty negotiations, as well as the very tight timeline, there is a realization that perhaps we need to look at voluntary hooks that would allow the conference of the parties to then in future create something more robust, something that is more binding, or create mechanisms, for example, a committee on EPR or some type of framework on EPR that could come out of the treaty. Um, this is not the only context where we're seeing this. We're seeing this in a number of other areas, certainly for subsidies, et cetera. So having voluntary language will probably feel very, if it happens, very much like a letdown to many people. But at the same time, I think it is also important. Any language is important. If we are to have a treaty that is done at the end of 5.2, any language that then allows us to make sure there is a reference to EPR that can be built on will be critical. Obviously, the more the merrier, and certainly if there could be one in the preamble, I think that would be the most powerful place to put it. But I'm not sure that there would be agreement on it at this point.
One other quick question,
Yeah.
and that is as I mentioned in my opening, chemicals and design are critical elements. And could you just give us a brief update about where the hazardous chemicals and the design for reuse issues
Yeah.
are?
So unfortunately for many of us, or fortunately, if you don't want to look at a very long treaty and the 70 pages was not attractive, we have seen chemicals of concern, plastic products, and primary plastic polymers, et cetera, all largely lumped together. So we now see an article on supply, and that has certain aspects of chemicals and plastic products. We have an article on plastic production and plastic products. And then we also have an article on plastic waste management. So they have been very much pared down and combined together, and elements combined together. So it's a bit confusing. I've been doing a number of tables, which for lawyers, doing tables is it's never a good thing. But I have been doing them to do comparisons, and you really do have to kind of use different arrows and everything to see where things have melded together. But that is where they are at present. Again, if I see anything more on updates, I will be happy to share that with you and with the group.
Alexandra, thank you very, very much
My
for
pleasure.
a very helpful summary of where we're at in the treaty.
My pleasure. Thank you.
Thanks, Alexandra. And now we'll pass it over to Ryo Fujikura, who's going to talk about EPR at the country level in Japan.
Yes, can I change the slide? Okay. So good morning. I will present on lessons from Japan's EPR-based Container and Packaging Recycling Act and an implementation for marine plastic reduction. In Japan, recycling acts based on EPR have been enacted for 4 categories: containers and packaging, home appliance, automobiles, and small electronics. The Container and Packaging Recycling Act was enacted in 1997. While each act mandates the responsibility for recycling costs, the timing and the parties responsible differ depending on the act. At this seminar, I focused on plastics and packaging. I will concentrate on the Container and Packaging Recycling Act. Next, please. Yes. In Japan, waste is categorized into industrial and municipal waste. Industrial waste must be managed by business, while municipal waste is handled by municipalities. Each municipality determines how it separates, collects, processes, and recycles municipal waste. Waste management must be tailored to local context. In my city, for example, Yokohama City has 3.8 million population, and waste is classified into 10 categories. In Kamikatsu town, where population is about 1,000, and the waste is classified into the most detailed categories in Japan, residents are required to separate waste into 32 categories. Next, please. This table shows the percentage of municipalities that collected separated containers and packaging in fiscal year 2023. For PET bottles, 99.7% of the population is covered by separated collection. The collection rate for paper containers is relatively low because many municipalities collect them with other recyclable paper, like magazines and newspapers, which can be sold for profit. The slightly lower collection rate for plastics is mainly due to the cost of separate collections, which I will discuss later. In such municipalities, plastics are always incinerated. Next, please. Although the bottles made from polyethylene terephthalate are commonly called plastic bottles in the US, I will refer them as PET bottles, the term used in Japan. PET bottles are considered a model case for successful recycling in Japan. This graph shows the recycling rate of PET bottles. In fiscal year 2023, 85% were recycled. Next, please. So PET bottle consists of different plastics. To produce high-quality recycled products, PET must be isolated. Municipalities instruct residents to remove cap and labels and rinse bottles before disposal. Then the bottles are collected and formed into clean bales. Next, please. Now let's turn to the Container and Packaging Recycling Act. It covers all containers and packaging materials, including plastic, paper, cans, and glass bottles. I will focus here on plastic packaging. And plastic waste is classified into plastic packaging and plastic products. The Act only applies to plastic packaging that is marked with the designated symbol. Residents must separate plastic waste from their homes into packagings and plastic products. Products such as bucket, toothbrush, DVD, toys, hangers, and gardening tools are categorized as plastic products to which the law does not apply. Therefore, municipalities incinerate them. Next, please. Here is a flow of plastic packagings. Under the Act, not only producers of packaging, but also business that use packaging must pay recycling fees to designated organization, JCPRA. Importers of packagings or packaged goods are also subject to this law. Small businesses, farmers, and independent stores whose annual sales are less than 5 million yen, about 3.5 million US dollar, or they sell less than a certain volume, are exempt from the obligation. Non-compliance results in fines. Residents separate plastic packaging from other waste, and municipalities bail and send them to recycling farms. Recycling plastics is not profitable, so recyclers receive necessary expenses from the designated organization. It was 43.5 billion yen. It's about 300 million US dollar in the fiscal year 2023. This account of 90% of the total 47.6 billion yen spent on the whole containers and packaging recycling. However, many municipalities are not enthusiastic. They have to cover the cost of collection, transport, and storage from taxes. In fiscal year 2003, the estimated municipal cost reached 30 billion yen, around 300 million US dollar. Next, please. So municipalities regularly take the collected waste out of the garbage bags to check how well residents are sorting their waste. If improper sorting is too often found, municipalities may issue warning or impose fines. The municipalities have been making continuous and considerable efforts to encourage residents to cooperate with waste separation. Next, please. This table shows actual sorting rate by citizens. While over 90% of PET bottles were properly sorted in the 2020s, only about half of other plastic packagings were separated. The rest ended up mixed with combustible waste. Items like ketchup or mayonnaise tubes or retort pouches are hard to clean, leading people to dispose them as combustible waste. Some residents mistakenly believe that plastic containers with food residues are not recyclable. Municipalities distribute pamphlets to newcomers and post guidelines online, but not all residents are reached. Language and cultural difference are other barriers where the foreign population increases. Next, please. In 2019, Japan introduced a plastic resource circulation strategy with specific targets. Number 1, reduction, 25 reduction in single-use plastics by 2030. Number 2, reduce and recycling, eco-friendly product design by 2025, 60% reuse and recycling rate for plastic containers by 2030, 100% reuse and recycling of all used plastics by 2035. Number 3, biomass and renewable use. Double recycled plastic use by 2030, introduce 2 million tons of biomass plastics by 2030. Next, please. This table, a Science Journal article estimated marine plastic leakage. It is believed that the publication of this article in 2015 prompted Japan to develop its strategy. Professor Toshihiko Matsuo, an emeritus professor at Hokkaido University, who has long studied waste management, has pointed out that estimation method used in the article has significant flaws and likely overestimate the actual leakage volume by a factor of 100. Especially in Japan, where coastal population and litter rates are extremely high, the overestimation of leakage is possibly by over 10,000 times. Next, please. Nevertheless, to meet the target, Japan enacted the Plastic Resource Circulation Act in 2022, covering plastic reduction and recycling across product life cycles. While not a full EPR system, it incorporates EPR elements. It encourages industry to design for reuse and recyclability. That is upstream responsibility. However, unlike the Packaging Act, it doesn't mandate post-consumer treatment responsibility. Next, please. For citizens, the practical change is that they can now dispose of plastic packaging and plastic products together. The central government provides financial support to municipalities for the expense of recycling plastic products. Therefore, this part is not EPR-based. Several dozen municipalities have already adopted this system. Next, please. For effective recycling, plastic must be properly sorted and cleaned. Clean PET bottles can be turned into high-quality product, including PET bottles and uniforms for municipal workers or convenience store staff. In contrast, unwashed or mixed plastics can only be recycled into low-grade product like pallets or artificial wood used in parks. Many plastics are turned into solid fuel. This is also recognized as material recycling in Japan. A considerable amount is also chemically recycled into fuel gas. Next, please. This chart shows plastic waste disposal in Japan. About 3.8 million tons each of municipal and industrial plastic waste are generated annually. Additionally, 600,000 tons are exported, mainly to Southeast Asia. Since China's 2017 import ban and tighter regulation in Southeast Asia, exports have declined. The 2019 Basel Convention Amendment further restricts export of mixed or contaminated plastics. Japan must now manage more plastic waste domestically. The Container and Packaging Act applies only to municipal waste. It was 860,000 tons annually, about 20% of total municipal plastic waste. Of what, 48.8% is incinerated with heat recovery. In industrial waste, 42.1% becomes solid fuel. Japan's recycling rate for municipal plastics is only about 20%, lower than in the EU. But this is because most is used as fuel or directly incinerated. Only about 3% goes directly to landfill. Next slide, please. For comparison, US EPA data shows that in 2018, the US generated 35.7 million tons of municipal plastic waste. It is 32.3 million metric tons. It is 8.3 times Japan's volume. In the US, 76.6% is landfill and 8.7% recycled. Next slide, please. This OECD-based chart compares waste treatment about member states. Since Japan's 1900s Night Soil Cleaning Act, incineration has been the core method, originally to prevent disease like cholera and plague. Today, the ultimate goal is to reduce landfill residues. About 75% of waste is incinerated, with only 0.82% landfill. With very limited landfill capacity, reducing incineration residue is Japan's top priority. In contrast, only 11.8% of US waste is incinerated, while 50% is landfill. Next, please. This photo shows a Japanese landfill site. Ash is placed over waterproof liners to prevent groundwater contaminations. Rainwater passing through ash is collected, purified until effluent standards met, and discharged. Groundwater monitoring is conducted regularly. Next slide, please. This chart shows waste disposal method in Asia. In East Asia and the Pacific, 18% of waste is openly dumped. In South Asia, it's 75%. I believe transitioning from open dumping to landfill and then to the proper incineration and barrier of ashes is very essential for addressing marine plastic pollution. Next slide, please. The right photo shows final disposal site in Marshall Islands and Tuvalu. The lower left is street in Allahabad, India. Scattered plastics are clearly visible. This is likely where marine plastic pollution begins. The upper left shows Japan's largest landfill site, a 518-hectare site serving Tokyo's 9.9 million residents by accepting incinerated ash. Next, please. This is the takeaway. EPR is an effective principle for assigning plastic waste cost to producers. However, as seen in Japan's recycling law, cost may be unfairly shifted to municipalities. High-quality recycling requires proper separation and cleaning at source. It's difficult to ensure through the public compliance. In many countries, addressing open dumping and leakage from landfill should take priority over recycling or substitution. Next, thank you very much for your attention.
Thank you so much, Rio, for that presentation. We're going to move on to Mallory Anderson, who will be talking about EPR in Minnesota, and hold our remaining questions till the end, since I imagine there will be some overlap in the topics here. Mallory's going to share her own slides, so I will turn it over to you, Mallory.
Hello, everyone. Let's see. Are my slides showing?
Yes, you're good.
All right. So I'm Mallory Anderson, coordinator of the packaging EPR law called the Packaging Waste and Cost Reduction Act in Minnesota. I work for the Minnesota Pollution Control Agency, which has oversight and enforcement duties associated with this law, as well as multiple duties directed to it to comply with the law itself, including administration of an advisory board, completing the needs assessment, management of a registration system for service providers who are providing recycling, composting, reuse services that manage packaging and paper products in the state. So some of the outcomes we anticipate from the Packaging Waste and Cost Reduction Act, or Extended Producer Responsibility for Packaging and Paper Products from the law in Minnesota, are that we expect or that we require packaging and paper products to be reusable, recyclable, or compostable by 2032. There are one-year extensions for technical and market challenges going through 2040. We anticipate it will reduce consumers' costs of recycling by at least 90% by requiring that producers reimburse the cost of collection and management of packaging and paper products starting in 2029. It'll be 50% reimbursement, the following year 75% reimbursement, and in 2031 and beyond, no less than 90% reimbursement. Reimbursement does not cover commercial entities for the most part. It's focused on residential, households, and schools and other nonprofit style operations. The law also incentivizes sustainable packaging through use of eco-modulation and that 2032 requirement, holding producers responsible to shifting their packaging toward more sustainable options. We envision that it'll expand options for refill and reuse by including goals for waste reduction and reuse, and expecting that investments are made to progress those options. It will expand recycling services and access and convenience by establishing producer funding for collection, establish convenience requirements for accessibility, and it'll resource collection and education consistently across the state so that all municipalities are receiving similar messaging and information on recycling. It'll also simplify and standardize recycling in multiple ways. It'll establish universal recycling lists that set bare minimums. It'll also, like I said, create more equal education and outreach across the state, and could potentially add collection options like at store drop-offs for retailers who want to opt in. So like I mentioned in the slide before, reimbursement is limited to residential, nonprofits, schools, public spaces. What's covered in the Minnesota law is a little different than what's covered in some of the other programs across the United States. But generally what we have in the Minnesota law is packaging, food packaging, and paper products being covered. And then there are, of course, exemptions to what's covered in Minnesota. For example, packaging related to medical devices, hazardous products or products managed through other programs like paint care recycling program. Some of these exemptions are written into the law and are just provided as is, while some exemptions require commissioner approval by the Minnesota Pollution Control Agency, and there will be an application process that requires producers to demonstrate why their product can't be reusable, recyclable, or compostable. Excuse me, their packaging can't be made reusable, recyclable, or compostable. So some of the agency duties, thinking about compliance and enforcement. So in addition to compliance and enforcement, we have many duties assigned to us in the law. We will be approving of plans and amendments to those plans, so that's some of our oversight duty. We'll be establishing statewide goals, and we'll be facilitating service provider registration, so the registration of collectors, material recovery facilities, potentially reuse facilities as they come online. Like I mentioned, there are also exemptions that will require agency review and approval. And we also must approve an auditor to complete a program audit the 4th year of each stewardship plan. So Minnesota established a shared producer responsibility system that will cover collection, transfer, sorting and processing, administrative costs, and refill and reuse system costs. The foundational aspect of all of these EPR for packaging laws across the country is to establish that sustainable funding and to expanding robust recycling systems for packaging and holding high standards for those end markets where those materials are going to be made into new products or packaging. So in Minnesota, we have that no less than 90% reimbursement by 2031, but this does allow the producer responsibility organization to voluntarily shift to 100% reimbursement if they find the cost sharing to be administratively burdensome, or if they identify that shifting from 90 to 100% may provide advantages to improving the program. In addition, in the Minnesota law, there's a requirement for infrastructure investments. So beyond just kind of the basic costs, this will help invest in maybe expanding opportunities for collecting more material or improving the system to result in higher quality material. And one example of this could be we have a really big challenge with small materials. They end up in the glass stream and contaminate it. So are there ways to invest at the material recovery facilities to get those small materials captured and recycled, for example? And those decisions are all informed by this needs assessment that will be going underway, and each state has its own needs assessment. So generally, how does this program work? Producers appoint the producer responsibility organization. The Minnesota law limits to one producer responsibility organization for the first program plan. It then allows future producer responsibility organizations in the future who may specialize around a specific material or packaging type. The PRO collects fees from producers, and then there are two main reimbursement streams, like I mentioned. The first is just that basic reimbursement for collection and other services, and then the second is for those infrastructure investments. In Minnesota, the state is responsible for several key aspects of the program. So it's also a shared responsibility model. The producer responsibility organization is not in full control of all of the decisions being made. And that includes this foundational study, the needs assessment, which is being directed by the Minnesota Pollution Control Agency, and informs the stewardship plan. And there are some explicit requirements where the plan needs to reference the results of the needs assessment. There are statewide collection lists which will be established by the agency, and then the agency also establishes those statewide goals. In a lot of these new programs across the country, there are advisory boards. This is a newer concept, and those advisory boards are made up of folks who kind of specialize in recycling and reuse programs and can provide advice both to the producers through the producer responsibility organization and the agency to help keep the law informed through that business sector and nonprofit sector perspective. These advisory boards bring that expertise of those working within the system and can help us create a larger collective thought and informed thought around bigger issues of packaging and products. So I mentioned the agency must set goals. This is a really key aspect of the Minnesota program, that there's a 2032 requirement set in the law. That's kind of the first layer of goals and requirements in law. The second layer is a requirement set by the agency for a recycling rate, composting rate, reuse rate, return rate of reusable packaging, a percent of covered materials to be reduced overall, and a percent of post-consumer recycled content to be used within packaging and paper products as applicable by material. And then there's a third set of goals set by the Producer Responsibility Organization in their stewardship plan for those same categories, but it must be set by material type. So for example, there would need to be a specific recycling rate for post-consumer recycled content for PET, for example. So as was mentioned before, the United States is starting to catch up on extended producer responsibility for packaging. This is a very high-level view of the 7 programs, starting with Maine in 2021 and through to Maryland and Washington, which both had their laws signed by their governors this year. So just demonstrating the stacking of our needs assessments, program plans, when fees come into play. And you can see the 2032 requirement in both California and Minnesota with the 2 finish line flags at the end there. And I will note in Minnesota, Maryland, and Washington, there's also an implementation fee, which is a new concept. So generally, for compliance enforcement with extended producer responsibility programs, I think one thing we see as a benefit of these types of legislation and policies is that they have an evolution of shared goals between business and government. I would say a lot of them are built off of voluntary recycling programs or actors within a certain material type who are wanting to see more recycling or better capture of their product, or accept that their product has significant environmental or human health impacts when improperly managed. So what I'm trying to say is that generally these laws have some level of underlying cooperation up front. And because of that shared responsibility model, they do kind of have a unique layer of their compliance and enforcement when there is a producer responsibility organization coordinating among many producers. So for the packaging EPR law in Minnesota in particular, one major change to compliance and enforcement was that the law outlined updated fine schedules specific to the law. So it built on the existing enforcement tools handed to the agency through prior legislation. And I would say generally, kind of the universal approach is by agencies and departments is to always strive for compliance, do the best that we can to make sure that folks have the information they need to properly comply with the law, if that's through notification or support services. There's been a lot of partnering with nonprofit organizations and, of course, the Producer Responsibility Organization to get information out to ensure compliance in the programs that are being set up for packaging right now. And then in addition, like I said, these programs kind of have that unique layer with the Producer Responsibility Organization. And that Producer Responsibility Organization also has inherent incentive to get as many producers engaged in the program as possible to distribute costs. And as you have the more producers who are participating in the program, the fewer free riders, the more appropriately fees then can be spread across all of the producers who need to comply. So I think some of the lessons learned from extended producer responsibility organizations over the last, or policies over the last 10, 20 years has been holding some responsibility around that producer responsibility organization as well. So in the law, you'll see that if a producer responsibility organization is missing their requirements, first, there's again that compliance step of working with them to amend their program plan to make goals maybe more realistic, or to invest more to meet those goals by amending their plans. But then if a producer responsibility organization continues to miss their goals or has some sort of extreme circumstances, the agency would be able to revoke their registration and seek a new producer responsibility organization to run the program. But again, like I said, generally the intent of these programs is we all have the same goal of reducing environmental and human health impacts from either the packaging or the paper or the products. And cooperative efforts are, of course, the primary focus. So from Minnesota Pollution Control Agency's perspective, there have been pretty limited cases of enforcement associated with product stewardship laws. There have been cases of abandoned materials that need to be properly managed and ensuring the cost coverage of that management. There have also been challenges with language that didn't allow for the reality of some of the challenges of managing these materials. So for example, in the Minnesota e-waste program, the law outlines 100% recycling for collected materials, but because a lot of the plastics, or rather some of the plastics associated with the collected e-waste have significant human health concerns associated with the chemicals used in them, there is some benefit to taking these materials out of the marketplace and not having them be recycled. So it's been difficult for smaller recyclers and businesses to manage contamination compared to larger recyclers who have more market options and overhead to dispose of those contaminated plastics. So that's been a significant challenge. In Minnesota is working within statute when a human health or environmental health concern has been raised that doesn't perfectly align with the statutory requirements, and it also kind of helps to illuminate some of the challenges of legacy waste, a waste that is still going through the solid waste system that hasn't moved away from, or that has been in a basement or stored for a very long time and may have some chemicals of concern still within it. Not that all materials are no longer facing those challenges. And then some national enforcement examples. One recent and one a little bit older, but not that old. So the two I would highlight is the overhaul of California's carpet program, which had a significant settlement and resulted in an overhaul of the law passed in 2024. And the second, again, these are not in Minnesota, but the second is a recent example from Washington, enforcing their post-consumer recycled content requirement, which resulted in fines of many companies who missed their targets. And I think we've seen a lot in the news that there's been a real big challenge sourcing post-consumer recycled content to meet these requirements that producers have. And we are seeing in a lot of the packaging laws, EPR packaging laws, that post-consumer recycled content requirements are being folded into those laws. For example, in Minnesota, there's a post-consumer recycled content requirement goal, rather, paired with an incentive through the eco-modulated fees. So that's the end of my slides. If there is time for questions or anything else.
Great, thanks so much, Mallory. Before we get to questions, our last panelist had some technical issues, so we're going to see if we're able to share a video recording of her presentation.
Good morning, good afternoon, good evening, everyone. It's a pleasure to join today's discussion. My name is Chosha Teva Berhandagun, and I am the Program Manager for the Institute for Global Environmental Strategies. Today, I'd like to share some ASEAN perspective on EPR implementation and how they relate to the global plastic treaty negotiations. Despite increasing attention in 2022, the world produced roughly 430 million tons of plastics. but only less than 9% was recycled. EPR is one of the most effective policy tools that can address plastic pollution, where we have to shift end-of-life responsibilities from taxpayers to producer. It creates incentive for better product design, provide dedicated funding for collection and recycling, and enable transparency through mandatory reporting. Globally, over 60 countries have adopted some form of EPR, but implementation is still uneven, particularly in developing countries. Having said that, this summer in August 2025, negotiators around the world reconvened in Geneva for INC 5.2. Across every DAP so far, EPR is one of the few policy levels that enjoy cross-regional support because it shifts the cost of waste management upstream, rewarding better design and financing collection. In ASEAN alone, over 31 million tons of plastic waste are generated each year, according to the ASEAN Regional Action Plan. However, waste collection and recycling systems vary dramatically across member states. EPR offers a strategic approach to address these gaps by shifting the financial and operational responsibility from governments and taxpayer to producer. This shift actually enables design improvement that make packaging easier to recycle. Dedicate financial through eco-modulated fees, and data transparency to guide better decision making. In many ASEAN cities, the informal sector already collects up to 60% of post-consumer plastic, but often without formal support or recognition. So when we talk about EPR in this region, it's not about abstract policy, but it's about unlocking real investment in local infrastructure to empower existing workers and support national circular economy goals. One major challenge with post-consumer recycled content is often more expensive than virgin plastic. Without incentive or regulatory requirement like those built into EPR system or those in the EU system, producers have little reason to choose recycled contents. Addressing this economic imbalance is essential if we want to scale up recycling and build local market for PCR in the region. In terms of ASEAN progress on EPR policy, we have seen encouraging momentum. Several ASEAN member states, including Malaysia, Vietnam, Thailand, and the Philippines, have initiated national EPR framework or roadmaps. However, the pace and readiness still varies among all of them. Challenges also include unclear producer obligations, limited enforcement, and fragmented data system. There are also pressing need to ally incentive, engage informal collector, and design fit-for-purpose monitoring system. I would also like to share case studies in ASEAN countries. For example, in Malaysia, corporate-led approach by MAREA, an industry coalition of over 50 brands that implemented a voluntary EPR initiative in place before federal law. In 2023, they actually collected 22,000 tons of plastic through member fees. For the Philippines, the Republic Act in 2022 mandates producers to recover 20% of their plastic footprint in year one, scaling to 80% by 2028. And major FMCG have formed PRO and reported early recovery of 120,000 tons, but there is pushback from SMA and concern from NGO about opaque chemical recycling credits. For Vietnam, Decree 08/2022 linked EPR fee to recyclability score, with PET bottle paying $45 per ton and multi-layer film paying $220 per ton. A central recycling fund now finances 6 provincial MRF, demonstrating the power of eco-modulation and targeted investment. For Thailand, Thailand implemented a voluntary EPR pilot program that provided financial top-up to over 6,000 informal waste collectors for PET bottles. As a result, PET bottle recovery rate increased significantly from 59% to 79% within just a period of 6 months. Building on this result, Thailand is now developing a draft EPR law that incorporates lessons learned from the pilot program and feedback gathered through stakeholder consultation. So where will the money come from to make EPR work? There are 3 practical ways we can raise the fund, at least. From producers themselves, if we collect a small fee, say around $30 to $40 per ton of plastic, and make sure it's used only for recycling and waste management, we could actually raise up to 600 million per year across the ASEAN region. Second, by blending different types of finance, loan from development bank like ADB combined with corporate commitments to buy recycled plastic. And the third, through international grants linked to the treaty. Once the Geneva text is ready, climate and biodiversity funds may support EPR system, especially those that reduce carbon emission. To help address these shared challenges, IJES has been working with our counterparts to explore the idea of forming an ASEAN EPR expert working group for plastic and packaging. The vision is to create a space for peer learning, share data, policy alignment. While this initiative is still in development and we are actively seeking funding to bring it to life, it could play a critical role in aligning ASEAN effort with global plastic treaty objectives. To help address these shared challenges in implementing EPR, including unclear legal mandates, lack of reliable data, and limited capacity in government agency, IJES has been working with our counterparts to actually explore the idea of forming an ASEAN EPR expert working group for plastic and packaging. And this vision is to create a space for peer learning, share data, policy alignment in the region. The proposed working group could play a critical role in ensuring the ASEAN EPR efforts are aligned with the objective of the Global Plastic Treaty being negotiated at the INC process. It could also provide a platform for capacity building, technical assistance, and knowledge sharing to support ASEAN countries in designing and implementing effective EPR system. It could also help mobilize funding and engage with the key stakeholders, including the informal sector, to ensure inclusive and sustainable EPR implementation across the region. So if your organization is interested in providing support, either through technical or financial support, please feel free to reach out to us. And this is just the roadmap to share what can be done to achieve the global plastic treaties objective. In terms of key compliance and implementation issues, despite growing EPR adoption, compliance remains weak in many countries due to unclear legal mandates, lack of clear and enforceable regulation for EPR implementation, absence of reliable data, for example, lack of comprehensive data on producer and packaging types. capacity constraints, limited capacity in government agency to manage and enforce EPR system. For ASEAN region, designing effective and enforceable EPR system mean addressing these foundation issues, especially for integrating informal workers and also SME. For EPR in the global plastic treaty that has been under discussion, Article 5 of the draft treaty focus on product design. Country actually support binding rules on recyclability, reuse, and transparency. Developing countries, including some of the ASEAN members, actually emphasize the need for capacity support and flexibility. At INC 5, many countries referenced EPR in Article 11 under finance and Article 12 under capacity building. So EPR was recognized not just as a domestic policy, but as a tool for generating finance, supporting circular design, and creating a scalable, compliant model. Let me also highlight some key positions from INC negotiations as well. Philippines, Kenya, and Uruguay actually support for global design rules. ASEAN countries, for example, Malaysia, Indonesia, actually straight national standard and affordabilities. Developing countries actually warn against design rule becoming trade barriers. Apart from that, there is also support for including EPR in the treaties. For example, Bangladesh, Kazakhstan, and the EU actually support the EPR, while Iran suggests it should apply only to developed countries. Others want to integrate EPR into their national action plans. Countries like those in the gulags, AGN, and siege actually support the polluter pay principle as a key principle for the treaty, for example. But what does this mean for the ASEAN countries? I guess there are at least three benefit from that. First, the opportunity to strengthen national EPR through the regional cooperation. The chance to align the EPR design with treaty requirements, including global standards and guidelines. Position ASEAN at a proactive region for circular economy and the treaty compliant. By aligning regional and global efforts, the ASEAN region can create effective EPR compliant mechanism that support local implementation and also unlock the full potential of circular economy. There are also key issues in terms of the implementation and compliance issue, including tracking compliance in informal economies. It's important to address challenges of monitoring and enforcement in the informal waste collection sector as well. Developing efficient mechanism for fee collection and management, especially in resource constrained setting. Integrated waste pickers and small medium enterprise into EPR system to promote equity and sustainability, and provide supportive tools and guidance to align national EPR policy with global treaty requirement. By addressing these key implementation and compliance issues, it will be crucial for ASEAN countries to effectively operationalize EPR and meet their commitment under the Global Plastic Treaty. Opportunity and way forward for the ASEAN countries. The ASEAN initiatives in the global treaties process can reinforce one another. It can strengthen national EPR through regional cooperation. ASEAN can leverage regional platforms to share best practices, ally policy, and build capacity. Ally EPR design with treaty requirements to ensure national EPR frameworks meet global standards and also enable treaty compliance. Position ASEAN as a proactive region for circular economy by demonstrating ASEAN leadership in implementing effective EPR system and driving the circular transition. With the ASEAN initiatives and the global treaty process can actually enforce one another by building trust, investing in data system, and aligning regional and global effort to create effective compliance mechanisms. With this slide, it just show I just actively contributed to the INC processes. We have organized several side events and also involved in the regional dialogues and other events as well. We have also have implemented several projects that align with the global plastic treaty objective. If you would like to have information about what we do in terms of plastic related project in the region, please feel free to reach out anytime. So let me end with this. EPR alone won't solve everything, but without it, we can't seriously tackle plastic pollution. Across ASEAN, we already have strong local examples showing that EPR can work when it's well designed and properly funded and inclusive of informal actors and also local system. So let's turn the treaty's ambition into something real. Thank you very much.
Great. Well, thank you to all our presenters today. We have about 20 more minutes for questions. I'm going to start with a couple specific ones for Mallory that I want to make sure we get to about Minnesota, and then I'll pass it to Lee to maybe ask some more general ones of all of our panelists. So Mallory, the first one would be, is there a reason for the exemption of commercial waste in the Minnesota EPR plan?
Yeah, some of the reasons for exclusion are primarily around the contracting procedure, that there's kind of like an interference and a complexity. So if you're a business in Minnesota that is also a producer, and then you're getting some funding for recycling collection, it creates kind of a complex system. So that was one rationale. But generally, there's just kind of a universal agreement by, it seems, a lot of the producer groups that help negotiate these laws, that the focus should be residential recycling first. And so I think you kind of see that in Colorado, and then you see that in Minnesota, where there's a big emphasis on focusing on residential recycling first.
Great. And then there's another question about whether, do the exemptions for specific products exempt only the packaging for a product, or does it also exempt an outer packaging like cardboard boxes that they might be shipped in?
That's a great question. So it focuses then on that primary packaging. But I think in some cases, we'll have to see for how exactly that looks. But I would imagine our focus will be that like primary container that's containing the hazardous or material of concern that it can't be managed.
There's another question about how the program in Minnesota will provide funding for reuse or refill systems.
Yeah, and we don't have a perfect vision of how the program will fund refill and reuse until we go through that needs assessment. As a lot of, packaging covers a huge broad scope of products, and not all products will be best suited for refill and reuse programs. So we'll be investigating which types of products can be most easily packaged through alternative processes, and then figuring out from the needs assessment and the plan how funding into that system will work.
And then the last Minnesota specific question is whether the states will establish mandatory recycling rate goals.
So in Minnesota, we will have mandatory rates that are being set.
Great. Well, thanks for getting into some of the details on that, Mallory, and I'll turn it over to Lee to maybe ask some of the more general questions.
Yeah, I have a few, and maybe I'll start with Mallory and then move on. We're now 7 states in the US with plastics recycling programs. I imagine that you talk to each other on occasion, and I'm wondering whether you've identified from sharing information what seems to be the biggest common challenge as you're implementing these programs. I know I've talked to some with California, and just identifying what's in and what's not in the program seems to be a big challenge for California, and writing the rule around that.
I would say interpretation of the laws at this point continues to be one of the biggest places of creating consistency among the 7 programs. In places where the statutes would allow us to do so is one place that we discuss as states, but also and taking statutory language, which is sometimes written in a way that is meant to be allowing different kind of interpretations, to be able to be flexible is also a big challenge. And then the nuance of, I think for producers going from state to state, that's one thing we talk about a lot. But I don't know that I could say one major thing has bubbled up. I think it just continues to be one learning after another, and we continue to wonder if things will just get easier now as additional states join, because of the more institutionalized knowledge by producers and the establishment of kind of this one universal producer responsibility organization that's helping to create consistency across the existing programs.
And I'll maybe follow that up with a question which you may or may not have some direct knowledge with, but the electronics EPR programs are much more mature in the US, and they've been around for 20 plus years. Are there lessons learned that from those programs that you're taking into account in the newer plastics and packaging
and some of the lessons learned that have been folded in is kind of a renewal of plans to create continuous opportunities for investigating the program's success and finding opportunities to improve it. But I think you also see, for example, in Minnesota, our architectural paint law is just a couple pages. And in addition, as we've applied lessons learned, it seems these policies are becoming much longer, with the Minnesota law, I think, being around 50 pages, and Washington having, I think, a 70 or 80 page law. So we are seeing a lot more complexity in the laws, as well as being able to apply lessons learned from the existing product stewardship programs we have.
And then I had a question that would go to all 3 of our speakers about issue I think that Chocho raised on data. Number one is, how is the treaty approaching the data availability issue? Secondly, for Ryo, about how what kind of requirements are there in Japan on data availability and how that's affecting enforcement, and the similar question for Mallory on data, whether it's related to plastics or the electronics waste.
Yeah. Well, may I ask you a question again? Whether you were asking about the electronics or the plastic?
Well, let's start with plastics. What kind of data is required to be made available by the product responsibility organizations and by the manufacturers, and is that public data? And is the data under your law, you think, sufficient to allow adequate enforcement of the law? And then we'll go to Alexandra and talk more about the treaty and data.
Yeah, I think that the municipalities are required by the national government to monitor how the waste is sorted. And I'm not quite sure what kind of some price. If the municipalities are well segregated, sorted beautifully, the national government gives some, I think, money to the municipalities. So therefore, also if if the national municipality found the separation is not good, they try to how can I say make more effort to educate, to give public awareness. But well, I'm not quite sure that how their activity for raising awareness is effective or not. In the small town, for example, the local people are watching each other, and some big man always instruct the local people who do not obey the regulation. But in a big city like in Yokohama, so there's no such relationship among the citizens. So that is, it makes the municipality more difficult to implement more effectively.
So the social norms vary quite a bit.
Right. That's
by
social
location.
chapter, yes.
Alexandra?
So I think the answer, Lee, is that we don't know yet, unfortunately, obviously, because we don't yet have the treaty. But this is one of the areas of tension in several ways. First of all, the dialogue around science, the dialogue around knowledge has become very tense. And there is, not only in the plastics context, but also in the context of the science policy panel negotiations, which are going on now, in the SICOM process that gave us the global framework on chemicals, there is a sense that understanding the science has become very political. We know this obviously from the climate context as well. And while there is agreement that we will have to have scientific knowledge in the treaty and in the COPs and the annexes that populate elements of the treaty, it will likely be highly contested. Because there are many different forms of language being proposed as to whether we use best available science, best scientific knowledge, how we verify that, various forms of language that are really quite technical, but do carry with them various degrees of kind of cynicism of the scientific process. So that's, I think, that's on the one aspect. The other aspect, when we're looking at the question of, how do we kind of mainstream in science, and how do we make sure that we have the scientific needs assessed for EPR, et cetera, is to figure out where the annexes will come in, what they will connect to, because we all kind of agree that there will likely have to be a number of annexes for this treaty to be adopted anytime soon. The question is how they link, and then how do they link to reporting? And a subsidiary issue there is that many companies and many countries that are home states to these companies have been very concerned about the public nature of the reporting requirements. and the public nature of the transparency requirements that will, for many countries, be very essential to be part of the treaty. And there is a concern that there needs to balance, the arguments tend to cluster around, there needs to be a balance with intellectual property rights and protecting intellectual property rights for various products, et cetera. Obviously, you're putting something on the market that has a potential human and environmental health concern impact. So there is that as well. But it has definitely become much more a rhetoric that we have heard as we've moved along. And certainly when I was in Bangkok for the intersessional work that was really focusing on chemicals and plastic products and plastic product design, there was a lot of tension and a lot of disagreement over how far you can take disclosure requirements and transparency requirements before you start getting into other international laws and then national laws on intellectual property. So, and I see Mallory nodding, so I feel like that's going to become an issue in her conversation as well. But those are really the key areas of kind of contest right now. Hopefully, in a few months, we can have another discussion about what is in the treaty, and then we'll figure out how we put it in place. But for right now, it's still kind of very much up in the air, and those are the points of contest.
Thank you.
And I'll build it. I think a lot of these conversations are very apparent when you actually read the extended producer responsibility laws, and that the producer responsibility organization, particularly in the Minnesota law, is aggregating that information. And it's not a producer by producer reporting or registration. All of that data will be aggregated into kind of general buckets of information. So we won't actually be seeing producer X, Y, and Z's specific metrics. That'll be kind of a part of this producer responsibility organization. And whether or not I would have to kind of consult I would say that's not going to be considered public data, what specific producers are being charged. We will have a schedule to know which materials are being charged what fee and how that works, but we won't have the traceability to say what individual producers are doing. We'll just be holding that responsibility on the producer responsibility organization. I kind of think of it of like a credit trading system potentially, where some producers are kind of already invested and moved very far towards post-consumer recycled content goals, and will kind of lift up some other producers as they shift. But that generally we won't have the granular data that maybe the treaty is hoping to negotiate, nor to hold specific producers accountable to specific actions. It'll be done on an aggregate level.
So I've just reviewed the new Maryland law, and that Maryland law places a great deal of responsibility on the producer responsibility organization to design the system, with a public input actually going in first of all the design, and then the selection of the responsibility organization. So it seems like that's an important element, is to ensure that an appropriate producer responsibility organization is selected that is financially stable and can manage the system. I don't know whether Mallory or Ray or Alexandra, you have any comments about that particular selection process, which seems very central to the US systems now.
I think just to jump in quickly and say, I think that, again, that's something that, as I was talking about in the discussion about whether this will be kind of voluntary or binding, and then whether these will be national or international standards, we see a lot of discussion around and a lot of concerns raised. And the concerns are obviously trying to balance, again, the idea of wanting a global standard on one hand. So we are kind of uniformly applying it and not giving some preference to certain markets or producers in certain markets over others. But then on the other hand, realizing that the needs of each country will be slightly different. And so how do we tailor those? Do we have one set of international kind of floor-based boundaries, and then you can go above it, but you can't go below it, something like that? Or how else do we do it? But it's really quite a critical distinction and discussion. And I think there are a lot of really interesting examples from the US too, because so many states have regulated and in somewhat different ways, incrementally different ways, that can actually be used as a really important tool, not only in the US, but also in other legal systems, even legal systems that are similar, have common traditions, but are still different enough in how they regulate and what the industries they have within them might be.
Good. I think our time is nearly at an end. So I think we'll stop there and thank Ryo and Alexandra and Mallory and Chocho in absentia for participating. And I'll turn it over to Susanna for last words. As I understand it, this video will be available on the ELI website with the slides. So thank you again, everyone, for a really in-depth conversation.
Great. Yeah. Thanks again to all our speakers, and thanks to Lee for co-moderating, and thanks to everyone who submitted questions. As Lee said, if you joined late or couldn't attend the full webinar, you can watch the recording on the event page at eli.org within a few days, and the slides that people presented will also be posted there as well. You can also find our calendar of future events, and we hope you'll join us again. So thank you so much, and have a great rest of your day.
Thank you all. Bye.
And good night.
Good night. Yeah, get some rest.